My lord.
Please write down Mr. Lal Tanpuya, learned counsel for the appellant, is said to have some personal difficulties to appear before the court today. On a mention made on his behalf and not objected to by the other side, matter stands adjourned for 2 weeks. All right.
For admission, item number 1.
If I may. Your Lordship, Mr. Pathak, counsel for the petitioner has requested me to appear on behalf of him. He has personal difficulties. He has received his affidavit filed by the state respondent. So, if I may be given further 3 weeks' time to file rejoinder affidavit.
On a prayer made on behalf of Mr. B. Pathak, learned counsel for the petitioners, 3 weeks' time is granted for filing rejoinder affidavit to the affidavit in opposition filed by the state respondents. List after 3 weeks.
Obliged.
Item number 2.
May it please, Your Lordship, we had filed the affidavit in reply yesterday, Your Lordship, and steps were taken on 14th of October for service of notice upon the respondent number 4, Your Lordship. And I think service report is still awaited.
Rejoinder affidavit is on record? It's not
filed
yet
it-
on record.
We filed it yesterday, Your Lordship.
Have you received a copy? Miss,
Yes, my lord, I have received a copy yesterday.
what do you say?
It's up to your lordship, my lord. We have already filed our affidavit in opposition.
Can it be heard today? Are you ready?
Yes, my lord. If your lordship insists, I'm ready.
If Your Lordship will take it up on Monday then, because I have a personal problem today.
Mr. A.R. Malhotra, learned counsel for the petitioner, submits that rejoinder affidavit has been filed on behalf of the petitioner. Stop. However, the same is not on record. Stop office to verify and connect the same to the record. Next para. List the matter again on Monday, 21st of October 2024.
But the interim order may continue.
Interim order passed earlier shall continue till the next date.
Item number 3.
Your Lordship, steps has already been taken for the newly impleaded respondent number 10.
When?
If I'm not mistaken, Your Lordship, in the month of September. ID card has not yet returned.
So we'll await ID card then.
Yes.
It is seen that AD card, no, cancel that. Neither AD card nor unserved notice has returned back from the respondent number 10. Although notice was sent. By registered post on 4/9/2024. Stop. List the matter again after 2 weeks to await service report from respondent number 10.
Obliged.
Item number 4.
Lordship, I am on behalf of my senior, Mr. Zoram Chana, today. Counsel for respondent number 3. Lordship, we just recently received the parawise comment from the AMC, and I'm seeking 2 weeks' time to file for affidavit.
My lord, I have received affidavit from the respondent number 1 and 2, And in the interim, if I may be kindly allowed the stay of the operation of the impugn order dated 4/7/2024, my
What is
lord.
the matter?
This is a matter regarding the transfer and posting of the petitioners to Lunglei Municipal Council from the Aizawl Municipal Council, my lord. So our claim is that this transfer and posting has been done in violation of our municipal act and as well as the service rules, my lord.
Where are you today?
I am at Lunglei, my lord.
Now?
Yes, my lord.
You've already gone to Lunglei.
Yes, my lord.
Then where's the question of stay then?
My lord, if the matter is stayed, then we can come back to our parent.
No. Had you come before the court before
Yes,
your
my lord.
departure to before your departure to Lunglei, that would have been a different question.
No, my lord, I have come and your lordship passed an order before as well.
No, we have not passed any such order. We have just said issue notice on the interim prayer. That's
Yes,
all.
my lord. At that time, I was not in Lunglei. So, being afraid of the actions that might have been taken upon me by my officials,
See, let them file the affidavit. We'll see. Plus, they want 2 weeks' time. You file by 2 weeks' time so that we can dispose it off on the next date.
Yes, Your Lordship.
You have 4 respondent numbers,
3.
3 only.
Yes, the MC.
And what is your submission?
Actually, this matter is taken up by Miss Mary, but she had already filed her affidavit in opposition.
She's filed.
Yes, my lord.
Yes, 1 and 2 has filed. Is right. Counsel for respondent number 3 submits that he has received instructions / parawise comments and therefore 2 weeks time may be granted for filing counter affidavit of respondent number 3. Stop. It is seen that respondent numbers 1 and 2 have already filed their counter affidavit. Next para, Ms. Valentina Laldin Sangi, is it?
Lajin
Laldin Pui, learned counsel for the petitioners submits that the impugn order dated 4/7/2024 may be stayed so that the petitioners can rejoin their original place of posting. However, since the respondents are since the counter affidavit is likely to be filed within the next 2 weeks, this court is of the view that the matter should be finally heard instead of taking up the matter in a piecemeal basis. In view of above, list the matter again on today's what date? 18th.
18.
List again on 5th of November 2024. The respondent number 3 shall file their counter affidavit on or before 1st of October 2024 so that an attempt can be made to dispose of the case by the next court date. List the matter again on 5th of November.
Oblige.
For hearing, item number 5.
Your Lordship, if the matter may be kindly passed over for the time being and taken up as last item.
You are praying on whose behalf?
Lord,
You are praying on whose behalf?
Mr. Bilaram Yang, counsel for respondent.
Is he here?
Yes.
Has he come?
Yes, my Lord, he's still having motion hearing at court number 2.
Okay.
That is all.
What do you say?
And my senior is on like in court with you.
Who is your senior?
Let's for Oma.
Okay. Okay. Passover for the time being.
Item number 6.
Your Lordship, my senior in the main council, Mr. A.K. Rokum, is on his way. He's reaching Temple Square, Treasury Square. So it may be passed over after the next item.
Okay, this matter is listed for hearing today, isn't it?
Yes.
My lord.
Can it be heard?
Yes, as of now, for me, my lord, I'm ready.
You're ready, Mr. Zoram Chana. What is the matter regarding?
Actually, this is regarding the alleged attachment of their Hmm. Provident Fund, my lord. Provident Fund, which they stated were attached by the MRB lodge. Which actually, my lord, is no longer part of the Provident Fund, lordship. Once that Provident Fund has been encashed and credited into the account of the petitioner's husband, my lord, then it becomes a normal fund, my lord. And the contention, my lord, is that Provident Fund account cannot be attached. That is, that we admit also, my lord. But it no longer is a Provident Fund.
What is the story? Otherwise, who is the petitioner?
Petitioner, my lord, is Mrs. Larin Moy, who is the wife of late P. Silal Nunmoya. P. Silal Nunmoya, during his lifetime, was the terminated employee of MRB Lodge.
MRB.
MRB Lodge.
What was he working as?
Working as branch manager, Lodge, senior branch manager.
Senior branch manager.
During his tenure as senior branch manager, there was a misappropriation of 9 lakhs of fund from the MRB account. And DE was drawn and penalty was also imposed on him.
Okay.
And he was terminated. And as a consequence of that, and in terms of the relevant regulations of MRB lordship, his money, his account can also, his any amount can be deducted, my lord, to recover the loss caused by him to the MRB. And in pursuance to that, the amount that had been credited to his account was deducted 5 lakhs, only 5 lakhs.
From where? 5 lakhs deducted from where?
From his account.
From his account.
His account, bank account.
Okay.
And that they state was part of the Provident Fund. But even though the source may be Provident Fund, but once it has been credited into the account, the savings bank account of the deceased terminated employee, then it's a normal account, my lord.
Okay. How much was misappropriated?
9 lakhs, over 9 lakhs, lord.
Then why did you deduct only 5 lakhs
That is the only amount that is available there, my lord,
in his account?
in his account.
So what about the remaining balance?
Remaining, no action has been taken. And now since he's already deceased, my lord, not pressed on, I think.
The remaining amount has been waived? Or what?
Waiving, my lord, I think there is no such order as such. But now no further action has been taken against him.
So now why this writ petition is filed?
They are now challenging that amount.
Deduction.
Yes.
The
Could not
challenge of the deduction.
deduction from his account, savings account.
Okay.
Saying that since the amount was coming from Provident Fund, that cannot be done. But once that is credited into his savings account, then it's a normal account.
That is your stand.
My stand.
Okay. Okay, let Mr. Rokum
Mike.
reach. We'll see. Meanwhile, I think that item 5 can be taken up. Councils are here.
Item number 5.
Please, Your Lordship.
Yes.
My Lord, this is an appeal against the judgment and order dated 30/1/2023, passed in eviction suit number 6 of 2020. Just one moment. 2014. I apologize. So, wherein the present appellant was ordered by the court of the senior civil judge to
Maha, both of you can go. This is the first appeal.
first appeal. May I proceed, Your Lordship?
Yes.
Yes. So the judgment and order dated is 30/1/2023, which is at page 158 of the paper book.
158.
158.
Yes.
So the present appellant was the defendant in this eviction suit number 6 of 2014. The relevant paragraph is at page 175.
Yes.
175 at para 36. May I read, Your Lordship?
Yes.
Just the paragraph. On hearing of both parties and findings and reasons on various issues, and on the basis of spot verification done by Land Revenue and Settlement Department and by this court, the defendant counterclaimant is directed to vacate his occupation of land beyond the area covered by his LSC number 203 of 86 by demolishing a some-type building, garage, and 4 water tanks within 3 months of this order. Further, the defendant counterclaimant is directed to pay rupees 10,000 only to the plaintiff as cost of the suit. With this order, the instant eviction suit number 6 of 2014 is disposed of. So, I would like to lay emphasis on the fact that the decision of this court of the senior civil judge, of the trial judge, is on the basis of a spot verification. Now, the brief facts of the case, Your Lordship. The appellant is the owner of one LSC number AZL 203 of 1986.
Defendant.
The defendant appellant is the owner of LSC number AZL 203 of 1986, which is at page 69. This had come to his possession by way of direct purchase from one Mr. Silova in the year 1994. Page 69 is the copy of the LSC.
Yes.
Whereas the present respondent plaintiff is the owner of one LSC number 103-702/012188 of 2014, which can be found at page 6.
Both LSCs are next to each other.
Yes, my lord.
There's some overlapping or what?
That is the claim by both parties. According to me, I am within my LSC, whereas the respondent plaintiff believes that I am overlapping her LSC. So, at page 12, Your Lordship, if Your Lordship can kindly turn to page 12, this is the LSC of the respondent plaintiff. This is the site map. Now, at the left-hand side, the date of survey is given, and right below that, it says this superseded house pass number dash. And even at the drawing, a handwritten note is there. Ramhi house pass atranga LSC Asiam ani. So this LSC was based on a previous house pass. So that is the situation. Now coming to the facts of the case, Your Lordship, the appellant herein, as plaintiff, had initially filed one declaratory suit number 5 of 2001 before the Assistant Deputy Commissioner IZOL.
Declaratory suit number?
5 of 2001.
Before?
The Assistant Deputy Commissioner. And the government, the state were arrayed as defendant number 1 to 4, and the present respondent was arrayed as defendant number 5. The limited prayer was that he should be declared the rightful owner of his LSC, that is AZL 203 of 1986, as per his site map. This declaratory suit was allowed by judgment and order dated 10/11/2006, which can be found at page 24. Page 24 is the judgment and order. Thereafter, Your Lordship,
What was this DS about?
this was to declare the fact that I am the owner of my LSC as per my site map.
203 of 1986.
Yes.
LSC number.
Yes. So ultimately that was allowed as prayed. However, the respondent herein, being aggrieved, filed RFA 21 of 2006 before the Additional District and Sessions Judge 1, Aizawl.
Where is that?
This is at page 35. Now the appeal was allowed and the judgment and order passed by the trial judge was set aside.
Okay.
Now, here I would like to take your attention, your Lordship's attention, to para 13, which is at page 40. With your Lordship's permission, I would like to read this para 13.
Yes.
LSC number 203/86 belonging to the respondent number 1 was submitted in the trial court. The whole area as per his LSC was 545.40 square meter, whereas his claim area was 895 square meter. As per the spot verification report of the revenue authorities, which is exhibited as Exhibit D2A, the respondent plaintiff frontage area as per his LSC was 52 meters, but his actual claim was 104 meter at frontage. The respondent plaintiff constructed RCC building, Assam type building, and one shed within his claimed area. As per spot verification of the revenue authorities, which is exhibited as Exhibit D1BC, the respondent plaintiff constructed Assam type and go down shed outside the area of his LSC. The only building within his LSC area is his RCC building. The spot verification report, exhibit as D2A and D1BC, say the same thing. The spot verification conducted by the revenue authorities stated that the area claimed by the respondent plaintiff is much larger than his LSC area. The plaintiff respondent then explained his position, stating that his wife purchased VC pass adjoining to his LSC 203 of 86, which is exhibited as Exhibit P10 in the trial court, and as such his LSC 203 of 86 plus VC pass area accommodated his claimed area. But as already stated above, the said VC pass is claimed by the respondent plaintiff is a Xerox copy, and there is no original copy, and therefore its existence is not proved in the trial court and is considered doubtful. On the other hand, the VC pass number 17 of 71, claimed by the appellant respondent, is also without blemish. The boundary description in the said VC pass and the land pointed out by the seller to the buyer, present appellant, may not be the one and the same. But as per sale deed given by the original owner to the buyer, present appellant, the land area started next to Putrasiama's respondent plaintiff LSC. There can also be the possibility of the original owner of VC pass 17/71 trying to sell the land not indicated by the said VC pass. In short, the appellant as well as the respondent could not satisfy the court as to their rightful claim. Both parties had dubious claim. They could not beyond reasonable doubt prove their rightful claim over the disputed land. In my considered view, the appeal has some merit as the evidence proved by the respondent plaintiff claimed the area much larger than his LSC number so and so, whereas the appellant land is not located anywhere. And I am constrained to hold that the trial court has failed to correctly consider the evidence on record. Accordingly, the appeal is allowed by setting aside the impugned judgment in order dated 10/11/2006. So, it appears that the first appellate court had this set aside the judgment and order of the trial court, not on merit, but due to lack of evidence on both sides. So, the merit in respect of either party was never mentioned by or was never declared by the first appellate court. As far as their rights are concerned, it's still in a limbo, so to say. So, thereafter, Your Lordship, the appellant, being aggrieved with that judgment and order passed by the first appellate court, filed a review. However, the said review was dismissed, saying that a review cannot take the guise of an appeal. So, in any event, that review was dismissed.
Review filed by the instant appellant.
Instant appellant. He was the plaintiff in that original declaratory suit.
In the appeal, you were the respondent.
In the appeal, I was the respondent, and I filed a review. The same was dismissed by judgment and order dated 30/11/2011. saying that you cannot file a review and reassert your claim as if it's an appeal.
Where is that?
This is at page 42. At page 44 is the relevant page. At the bottom, perusal at the last third paragraph. Perusal of the impugned judgment would reveal that the issues involved were decided with reasons after considering the facts and law and ultimately came to the findings that the judgment in order dated 10/11/2006 passed by the trial court was liable to be set aside. There is no error prima facie in the record except for the clerical error stated above. The grounds of review taken by the petitioner in my considered view cannot be cured by this court in exercise of the power of the review. Modification of the judgment on these grounds would amount to exercise of appellate jurisdiction.
Then
Thereafter, again,
this became final.
no, my lord, the present appellant approached this honorable court again by way of a CRP at page 45. However, that was also dismissed. At page 45 is the order of this honorable court in CRP 7 of 2012. The relevant paragraph is at page 47. Having heard the learned counsel for the petitioner and on perusal of the materials on record, I am in agreement with the view expressed by the learned lower appellate court while rejecting the review petition. By way of filing the review petition, the petitioner had virtually sought for a rehearing of the appeal on merits, which is not permissible in law. In the opinion of this court, if the petitioner is aggrieved by the appellate judgment and order dated so-and-so, the remedy lies elsewhere and not in filing review petition. In view thereof, I do not find any infirmity of the view taken by the learned additional district and sessions judge. I join in rejecting the review petition. Accordingly, this revision petition stands dismissed, but without prejudice to the right of the petitioner to avail such remedy which may be permissible in law. And as far as this particular the declaratory suit initially filed by the appellant is concerned, this was the end. In any event, what transpires from all those various rounds of litigation is that
Declaratory suit was allowed.
yes,
Appeal, it was set aside. Then you filed review. This
Dismissed.
rejected. CRP
Rejected.
again rejected. CRP was under what provision?
I believe it's 115.
115.
It's not exactly mentioned. I only have the copy of the order, not the petition, but it must be 115 in my humble opinion.
So your declaratory suit has remained non-effective.
Non-effective, and my rights so far as or the extent of my rights as per my LSC was not established or was not affirmed by any court of law, and but the same goes for the respondent as well.
Okay, so now how does this case crop up now?
Right. So thereafter, Your Lordship,
Who initiated?
the present respondent as plaintiff filed the eviction suit number 5 of 2014.
Eviction suit.
Yes, which is at page 52. This was the first eviction suit filed by the respondent plaintiff. This particular the first eviction suit filed by the respondent plaintiff was rejected on the grounds of pecuniary jurisdiction, but thereafter it was filed again, and the second eviction suit, which is registered as 6 of 2014, was filed before the appropriate forum, that is the senior civil judge, which is at page 1.
5 was filed initially.
Yes, initially it was filed, but due to lack of pecuniary jurisdiction, it was rejected. And then, thereafter, the present respondent appellant reapproached the court of the senior civil judge and filed eviction suit number 6 of 2014, which can be found at page 1 of the paper book.
This was the court of civil judge.
Civil judge,
Pecuniary jurisdiction was limited to
2 lakhs back
2 lakhs.
before that.
So where's the second one?
Second one is at page 1.
Page
one of
1.
the, yes.
Okay. Senior civil judge.
senior civil judge, and this was properly entertained, and it was basically narrating the facts, and thereafter, the prayer is that the defendant should be evicted from the land of the plaintiff. Now, at this point, I would like to stress on the fact that the first appellate court had come to a finding that neither parties could establish their actual boundary. So, even the plaintiff has not established to what extent is her rights as far as her LSC is concerned.
So all those process has been narrated here in this civil suit,
Yes. The eviction suit, my lord.
in the eviction suit.
Yes. So that was narrated. And thereafter, I also filed my written statement as well as counterclaim, which is at page 53.
Now, before that,
Yes.
where is the claim in the eviction suit about ownership by the respondent?
At para 3, the plaintiff respondent has said that the plaintiff is the rightful owner of LSC number so-and-so, which is located at Zone Wamaizol, which is converted from VC Pass number 174 of 1971.
There's some construction over the land which is in dispute.
My lord.
Is there any construction?
According to the spot verification relied upon, I have constructed a garage, 4 water tanks. Yes, that's it.
Inside the land of the,
Within the, beyond my LSC.
beyond your LSC and within the land of the opposite party?
I would not use that term exactly because the rights of the respondent to the extent of her LSC
No,
has not
the
been-
allegation is
The allegation, that is the
that
allegation.
is the allegation.
That is the allegation. But
Because-
what I would like to stress on this para 3 of the eviction suit of the plaint of the respondent is that the plaintiff has also claimed that her LSC was converted from VC Pass number 174 of 1971. But this VC Pass was never produced before the court. And her LSC clearly states that the LSC was in supersession of a house pass. That was also not produced. So those are some of the grounds that I will be raising going forward. So I filed my written statement, which can be found at page 53.
How much is the area of the land which the opposite party wants you to be evict, to vacate?
The
Water tank? How many water tanks?
4 water tanks,
4 water tanks and what else?
1 garage.
1 garage.
Yes.
So, any other area of land? Or just the area of land covered by these?
By those property, I mean like
Right.
those construction, so to
Okay.
say.
Now, was there any sort of complaint before the revenue department?
It appears so, Your Lordship. There is a spot verification which talks about that.
Now, before going to the court?
Yeah. I believe there was some attempts were made. I cannot exactly say because
That was not revealed in the process of the eviction suit. This is basically between two parties.
between two parties. I believe some attempts were made.
Because normally you see, if there's a issue of some land being encroached,
Right.
normally one complaint goes to the revenue department. They send the surveyor and they come and take the measurement and all that.
I believe that survey was also conducted in that declaratory suit also as mentioned in the RFA. Because in the RFA, the first appellate court had clearly mentioned the areas claimed by the appellant or the present appellant as plaintiff versus the actual area in his as per his LSC. All those things were mentioned.
So, end of the day, like you had referred to earlier, the first instance, that you wanted to stress upon the verification. That is the only means of settling. Otherwise,
that is the essence of this entire
the
appeal.
court cannot, sort of settle that
Right.
this should go there, this should go there.
So basically, Your Lordship, our only grievance is only two things. Number one, as I had mentioned earlier, the plaintiff herself has stated in her eviction suit that her LSC is based on a VC pass. Perusal of the LSC says that it's in supersession of the house pass. So in my humble opinion, it was the duty of the trial court who ordered for a spot verification to examine those documents and not just rely on the LSC alone, because the area in the house pass versus the area mentioned in the LSC could differ. That's number one. And number two is that, as I read out in the judgment and order passed in the eviction suit, the conclusion or the decision was arrived at based on a spot verification conducted by the revenue on as per the direction of the court. Now, when that spot verification was conducted, I was not present. I was absent because I had contracted COVID-19 at that point of time. And
When was it done?
that fact is also mentioned in the spot verification itself. The defendant is absent
So,
today.
who all were present?
Only the revenue and the plaintiff.
Revenue and the plaintiff.
Right. So I was not given an opportunity of being heard. And number two, the spot verification, the basis of which the decision was made, the author of that document was not produced as a witness, thereby denying me an opportunity of cross-examining the author. So those are my two limited grounds. And on that, Your Lordship, I have given one judgment. I'm relying on only one judgment. I've given this judgment 2010 volume 4 SCC 491. 2010 volume 4 SCC 491. I will only rely on this.
Paragraph?
Para 25 onwards. Lordship has it.
Yes.
Para 25. We are of the firm opinion that mere admission of a document in evidence does not amount to its proof. In other words, mere marking of exhibit on a document does not dispense with its proof, which is required to be done in accordance with law. As has been mentioned here in above, despite perusal of the record, we have not been able to come to know as to under what circumstances the respondent plaintiff had admitted those documents. Even otherwise, his admission of those documents cannot carry the case of the appellants any further, and much to the prejudice of the respondent. It was the duty of the appellants to have proved the documents exhibits A1 to A10 in accordance with law. Filing of the inquiry report or the evidence adduced during the domestic inquiry would not partake the character of admissible evidence in a court of law. That documentary evidence was also required to be proved by the appellants in accordance with the provisions of the Evidence Act, which they have failed to do. I would like to skip to para 30.
Yes.
From the narration of the aforesaid facts and law, we are of the considered opinion that the courts have committed no error in coming to the conclusion that the respondent was denied the opportunity of hearing. That being so, the whole proceeding stands vitiated by non-adherence to the principles of natural justice. Under the law of evidence also, it is necessary that contents of documents are required to be proved either by primary or by secondary evidence. At the most, admission of documents may amount to admission of contents but not its truth. Documents having not been produced and marked as required under Evidence Act cannot be relied upon by the court. Contents of the documents cannot be proved by merely filing in a court. So my humble submission is that, number one, I was denied the opportunity of being heard when the spot verification was conducted. Number two is that the decision of the trial court, having been based on the spot verification report, that document was required to be proved by calling upon the author of the report and allowing and giving me an opportunity of cross-examining the author to ensure the truthfulness of its contents. And secondly, Your Lordship, as I had mentioned earlier regarding the past, and as I had mentioned earlier in the order passed by the First Appellate Court, the plaintiff respondent herein has never confirmed the extent of her past as per her LSC, and the same has never been confirmed in a court of law. The decision of the appellate court was that neither parties could substantiate their claims up to the extent of their what is the extent of their land. In fact, it was held by the First Appellate Court that when the actual seller who sold the property to the present plaintiff respondent might have pointed to a separate some other location, and all those facts are there. So in my humble opinion, before filing an eviction suit, it was the duty of the respondent plaintiff to first establish what is the extent of her actual rights as far as her past is concerned. And for that purpose, the previous passes, such as the VC passes, the house passes, they ought to have been submitted before the court and exhibited. And based on that, what is her exact extent of her area should be established first. Only then she would have, in my humble opinion, the locus standi to file any eviction suit against the present appellant. So that is the limited grounds, Your Lordship. Those are the facts. Apart from that, we are not raising any other grounds, Your Lordship. In fact, Your Lordship, in the judgment and order at issue number 2, the trial court had even stated that there was no overlapping of LSCs.
In which case?
In the present case.
No. In the eviction suit?
In the eviction suit. Judgment in order is at page 158.
Yes, which rabbit para? Para 18.
No, my lord. Page 169, issue number 2.
One 169. So this is the issue which is relevant, I think, whether there's an overlapping or not.
At para 27 onwards, on the basis of the above evidence, it is evident that the defendant got a plot of land from Pisailoi bearing LSC number so-and-so, and thereafter the plaintiff got a plot of land at the adjoining land of the defendant, and measurement of their boundaries matched each other. That is 25.98 meters along the boundary pillar number so-and-so of the plaintiff and pillar number so-and-so of the defendants. Hence, the present issue is decided on the negative that the land covered by LSC number 203 of 86 is not overlapped by LSC number so-and-so. So there is no overlapping, but yet there is an eviction suit, order for eviction. So, as such, due to these reasons stated that I've raised, Your Lordship, it is our humble prayer that this honorable court may be pleased to set aside the judgment in order dated 31/2023 passed in eviction suit number 6 of 2014. With that, I conclude my submission, Your Lordship.
My lord,
Mr.
yes.
Bilaramenga,
Yes, my
I
lord.
think you are very aware, you're conversant with this judgment. LIC
Yes,
of
yes.
India, Rampal Singh.
That is true, my
You
lord.
had cited this the other day.
Yes, that is true. But however, your lordship, in the present case, my contention is that yes, it is true to say that there is no overlapping of the two LSCs which are lying adjacent to each other. But now the only question, the reason why eviction suit was filed is that the present appellant had encroached upon my land. He had constructed the Assam type garage as well as 4 water tanks. And upon the finding made by the learned trial court, yes, he had constructed those structures within my land, and he was directed to vacate the land wherein he made such constructions, to demolish the constructions also. There is the only question. So the only issue is,
There may not be any overlapping.
yes,
Both are separate, no overlapping.
lying
Yet-
adjacent.
Yet the other side can construct
Exact-
some structure within your land.
Exactly, my lord. That is the only issue. So it was found by the learned trial court that yes, he actually illegally constructed those structures within my
Where
land.
is that finding?
The finding is, my lord, the finding is based upon 2 things. The first thing is from spot verification. Yes, admittedly it is true that the local commissioner surveyor was not examined before the court. But the other evidence is there, that is under Order 8 Rule 18, court had personally, the judge himself inspected Order 18 Rule 18 CPC was invoked, and the judge has personally inspected the site. And on these 2 points on the basis of 2 grounds. The finding was made, my lord. And it is clear from page 172 of the paper book.
Page
172, my lord. My lord, if I may read from para 30,
yes.
then I'll come to para 30 to 32, I'll read, my lord. Considering the evidences for both the parties, it is the evidence of the plaintiff that the defendant encroached her land by constructing a sum-type building and 4 water tanks, while the defendant has claimed that he had constructed concrete building and a sum-type building within the area of his land. On careful examination of copy of LSCs as exhibited by both the parties, the frontage area of the plaintiff LSC along the metal road from pillar number 1 to 2 is mentioned as 12 meters and 2 to 3 as 40 meters, that is 52 meters frontage along the metal road, while the frontage area of the defendant's land along the metal road is mentioned from pillar 1 to 3 as 52 meters, which means the total area of the frontage along the metal road covered by the land of the plaintiff and the defendant is about 104 meters. However, the plaintiff did not make any development over the land due to encroachment by the defendant, while the defendant has constructed concrete buildings and a sum-type building along the metal road. During the course of the trial, the learned predecessor court had made an order for spot verification of the disputed site, and in compliance of the said order, spot verification was done on 12/11/2021 by Land Revenue and Settlement Department, Government of Mizoram, and the verification report was exhibited as court exhibit and marked as exhibit C1, wherein the detailed officer had reported that as per the instruction, he has done the demarcation of the plaintiff's land and angle posts were erected as boundary pillars along the road. That although he has instructed the plaintiff to reinforce the boundary pillar with cement concrete, the said pillars were taken by the defendant and later on they had recovered with the help of the police. It may also be pertinent to mention that while preparing this judgment, this court personally visited the disputed site on 20th December 2022 at 1 p.m. in which it is found that the defendant had constructed a sum-type building and garage along the metal road and water tanki inside the disputed site, and the defendant fairly informed this court that he did not allow the plaintiff to erect boundary pillar since he did not accept the said boundary. The defendant further informed that this court, although the frontage area of his LSC is 52 meters, he had occupied 98 meters along the metal road by constructing concrete building, a sum-type building and garage, and his reason for doing so is that the plaintiff purchased a plot of VC pass elsewhere but wrongfully converted the VC pass into LSC to the present site. So, my lord, he also had personally visited the disputed site. And the reason why I'm emphasizing on is that, my lord, Order 18, Rule 18, CPC, if I may refer before.
Just a minute, before that,
my lord.
This particular sentence,
My lord.
the defendant further informed this court that although the frontage area of his LSC is 52 meters.
Yes.
Whose frontage area? Defendants or plaintiffs?
Defendant, my lord, the present appellant. He also admitted that his LSC, because the present respondent
52 meters.
Yes.
He occupied 98 meters.
98 meters.
And reason is that he purchased plot of VC pass elsewhere,
Yes.
but wrongfully converted the said VC pass into the present
No,
site.
There was no challenge
the
at all.
plaintiff purchased VC pass elsewhere, but wrongly converted the set LLC in that present site.
This is a narration of the defendant
Right,
about plaintiff.
right.
Yes.
That is what I was trying to
Yes,
understand.
yes. Narration of defendant before the learned judge.
Defendant further informed the court, although frontage area of so-and-so is this much, he occupied this much. And the reason is that he purchased VC pass from elsewhere and wrongfully converted the pass into LSC. So 52 became 98. This is the allegation against the plaintiff.
Allegation against he admitted, the appellant had admitted before the learned trial court that yes, the frontage is 52 meters. but
Whose
he
frontage?
His LSC.
Plaintiff's frontage?
No,
Or
no, my lord.
defendant's?
Defendant's LSC. The plaintiff is a woman. So it is written here, his LSC. He
Okay.
confessed before the court that yes, his LSC was 52, but he occupied more than that, 98. So it is very clear, my lord. And the reason for this is that he alleged that I, being the respondent here in my lord, I had purchased the other land elsewhere, but that wasn't challenged. That was not the issue.
Some language problem is here.
Yes.
It,
Somehow
it
difficult.
concludes by saying, but wrongfully converted to the VC pass. So
Yes.
the defendant, did he say that I wrongfully converted the VC pass into LSC? That's why I'm occupying 98 meters. He couldn't have said that.
Yes. This is regarding
This is
plaintiff
a
VC
this
pass.
is a perhaps the finding of the court.
Yes.
But wrongfully converted the said VC pass in LSC is a finding, I think, on this issue.
I think this is still the narration of the defendant. my
But it
lord.
doesn't make any sense.
It's somehow confusing, in fact.
Court personally visited the disputed site and found construction, some type building, garage, metal road, water, so and so. Defendant fairly informed the court he did not allow the plaintiff to erect boundary pillar, since he did not accept the said boundary. The defendant further informed the court that although the frontage area of LSC is 52 meters, he had occupied 98 meters along the metal road by constructing concrete building, a some type building and garage. And his reason for doing so is that the plaintiff purchased a plot of VC pass elsewhere, but wrongfully converted. Okay. Okay. He admitted that he
occupied more than the actual frontage.
52 meters, 98 meters.
Yes.
That's a vast difference. Almost double. Particular paragraph 32.
32. Here, my lord, the learned trial court had made an observation which was to the effect that the defendant himself admitted before the court that he occupied more than the actual frontage area. 52 was the actual frontage area, 52 meters, but 98 meters was occupied by him. And the reason why he occupied by him, according to the defendant, according to the present appellant defendant, is that the present respondent, that is the plaintiff, had purchased the plot of VC pass elsewhere and wrongfully converted this VC pass into the LSC, and by virtue of that LSC, she claimed the disputed land. That was what the defendant had stated. The reason why he occupied more than the actual frontage area. But that overlapping is not the issue, my lord. They are actually
No,
occupying.
plaintiff purchased some VC pass some elsewhere and wrongfully converted into LSC.
Yes, that is the allegation.
Okay, fine. But because of that, why does the defendant have to extend his land
That is
from
true,
52 to 98 meters?
That is true.
Doesn't make any sense.
Yes. If that is the allegation, then he should have filed a suit, different suit, claiming that I had wrongfully claimed the disputed site. But nothing was done by the present appellant. So the reason why I'm referring here is that, my lord, this has the weightage and the relevance in coming to the conclusion, passing the judgment and order, my lord. Because if we look at Order 18, Rule 18 CPC, the court can personally inspect the sued land.
If your neighbor is wrongfully expanding his land, you also will expand.
Yes. That can't happen, my lord.
Is that what it means?
And it wasn't challenged at all.
You wanted to show Order 8, Rule 18.
What I'm trying to say is, I'll refer to Order 18, Rule 18, my lord.
Order 8 or 18?
Order 18, Rule 18.
Yes.
My lord, power of court to inspect. The court may, at any stage of a suit, inspect any property or thing concerning which any question may arise, and where the court inspects any property or thing, it shall, as soon as may be practicable, make a memorandum of any relevant facts observed at such inspection, and such memorandum shall form part of the record of the suit. But here I haven't found any memorandum such recorded by the learned trial court. But it has stated in the judgment itself that the court had personally inspected the suit land. And while referring to this, my lord, I may rely on one judgment of this honorable court reported in 2013 volume 3 GLR 2013 volume 3 GLR 586. Relevant operative paragraphs are 17, 20 and 21, my lord. 17, 20 and 21. This which I am referring to is also pertaining to inspection of the suit land. This regarding title suit, my lord. This is a Shillong bench. I may read para 17, my lord, and those
Yes.
17, 20 and 21 I'll read. On going through the foresaid provision of law, I have found that the very purpose of the Order 18, Rule 18 of CPC is to help the court to understand well the evidence brought on record by the witnesses of the parties before the court, and up to that limited extent, the court can conduct inspection of any property or thing connected with the suit. Therefore, at any stage of the suit, in my considered opinion, means any time after putting in evidence on record by the parties or any one of them. And I'll come directly to para 20. I have already found that when one reads the judgment under reference in its totality, there cannot be any escape from the conclusion that inspection can be done by a judge under Order 18, Rule 18 of the CPC only to appreciate the evidence on record. Emphasis supplied by me. Thus, I have found that the judgment relied on by the parties helps only the contention advanced by the learned counsel for the petitioner plaintiff. Para 21. In view of what I have discussed herein before and what have emerged therefrom, I am of the clear opinion that inspection under Order 18, Rule 18 of the CPC is permissible only when there is evidence on record and not otherwise. Since evidently and admittedly no evidence is recorded in connection with TS number 23 so and so, the judge was not right in passing the order under challenge for holding inspection of the suit land on 5/11/2011. But in the present case, evidences were taken. After evidences were taken, my lord, inspection was conducted. So in the present case which I have cited, evidence was not taken. And inspection was done prior to that.
What were the evidences taken?
Evidences taken were the plaintiff and two other witnesses, my lord, were examined, and even the present appellant defendant had also given evidence, my lord.
Defendant cite how many evidence? How many witness?
I think only one, my lord. Only the defendant himself.
Defendant himself.
Yes.
Then plaintiff cite plaintiff and two others.
Plaintiff and two others,
Who are those two others?
my lord.
Sister and aunt.
Yes.
Sister and aunt. They also reside in the same house or the same property?
I'm not sure, my lord. Sorry.
Okay. Because if they are witnesses, they should be aware about the location, the area,
Yes.
and all that.
Yes.
They have to be well conversant. Otherwise, they just vouch because they are relatives.
Yes. And the last point, my lord, which I would like to point out is that para 39 of the paper book will also be relevant. This is the judgment earlier passed in that appeal regarding the declaratory suit which was filed earlier, my lord.
That 39.
39. Page 39 of the paper book.
What is this? Page 39.
Page 39. In the
This is
declaratory,
part of what?
yes, part of the record.
No, part of which record?
The judgment and order, this is passed in the RFA, which was earlier
Okay,
disposed
RFA.
of, my lord. My learned friend had mentioned about that.
Paragraph
Paragraph 11.
11.
Yes.
Yes. What is this?
The last ground raised by the appellant is that the trial court failed to consider the evidence on record in its proper perspective, which proved that the respondent number one was occupying the area, an area larger than the area covered by his LSC SZL 203 of 86. The witness for the pro forma respondent 2 to 5, namely Ngurchi Ngasilo, in his deposition, has stated that the frontage of the LSC number SZL 203 of 86 belonging to the respondent number 1 was 52 meters. However, he was claiming 102 meters on ground. This statement of the said witness was not made to be denied by the respondent number 1. This piece of evidence was not considered by the trial court while deciding the issue framed by it. The evidence on record proves that the respondent number 1 is claiming a larger area than the area covered by his LSC number 203 of 86. And the next page, para 13.
No, this is a ground raised. Is it also a finding?
Yes, the finding is at the last sentence, my lord. The evidence on record proves that the respondent number 1 is claiming a larger area than the area covered by his LSC SZL, so and so.
So, what is the evidence on record?
Evidence on record is this is regarding declaratory suit, which was earlier filed by the defendant.
I know that, but
my
the thing is that to say that evidence on record says that this is like that,
Yes,
he has not substantiated. What is that evidence?
this is
So,
the
question is that what is that evidence?
Murching a silo evidence, my lord. Murching a silo's evidence. At the preceding sentence,
Witness of pro forma respondent number 2 to
2
5.
to 5.
Pro forma respondent.
This is state witness.
Okay, 2 to 5. Murching Asilo. Who is he?
He was working at that time as a superintendent,
Of?
one of the staff of the revenue, my lord. Because paper book doesn't contain all the previous depositions.
Now, how does he know that the size of the land is this much and the respondent,
He was the official witness, my lord.
Art Hasiyama, has occupied land beyond his area of land? How does he know that?
He was the official witness working in the revenue department. Because the spot verification is also mentioned about spot verification earlier conducted.
Was he a part of the spot verification team?
That is,
Murching
my lord,
Asilo.
so far as the record is here with me, there is not manifested, my lord. That cannot be known. But next page, page 40, para 13, mentions about the spot verification, which was earlier conducted. And spot verification also stated that area claimed by the respondent plaintiff is much larger than his LSC area. Para 13 first paragraph will be relevant.
Mr. Fakoma says that the appellate court has not decided the controversy in favor of either of the parties. What do you see your submission on that?
My lord, it has decided this particular paragraph 11 and 13 itself had also clearly stated in that declaratory suit earlier filed by him. Because the only issue considered is that whether he claimed the area larger than his actual area and whether the construction made by him fell within my land. Because there is no overlapping of the two LSCs, my lord, two passes. We had no dispute regarding that. The only dispute is regarding illegal construction within my land. And he also knew it very clearly, my lord. He admitted before the learned trial court.
See, the suit is regarding declaratory suit.
Yes,
Please declare that I am the rightful owner of my property covered by LSC number so and so.
my lord.
That was allowed. But here's a case wherein the allegation is that, leaving aside his own property, the appellant or the defendant has constructed structures beyond his land. Correct?
Yes. In the eviction suit, there is the issue. But even in the declaratory suit also, my lord, his relief claimed was that the area which he was claiming and wherein he constructed those structures also within his LSC. So he claimed in that way. But the finding in the appellate court was that no, he claimed the area larger than his actual area.
No, in the declaratory suit.
Yes.
That was the claim.
There was also, yes, my lord, in the declaratory suit, his claim was that the whole area which he claimed as his own area fell within his LSC. That is the only reason why he filed the declaratory suit. Just to confirm that, my lord, he filed the declaratory suit just to declare that he is the rightful owner of the LSC possessed by him, and he does not encroach upon the land of the present respondent. But he didn't succeed because he actually encroached upon my land. And the finding by the appellate court was that he claimed more than his LSC area.
Purpose of filing declaratory suit was for declaration that the plaintiff is the rightful owner of the suit land covered by so-and-so and does not encroach upon the land of the defendant number 5.
Yes.
And the finding is that suit is allowed, plaintiff is declared the legal and rightful owner of the land.
My lord, if I may, in that regard, on that subject, at page 33 at the bottom, the declaration was filed in respect of an LSC as well as a VC pass. It is not only confined to an LSC. Page 33 at the bottom, it's mentioned.
But then again, in the appeal,
It was set aside. And findings were also recorded, which I have read out, my lord.
what is the VC pass? It's just a date only, is it? There's no number, isn't it?
Yes.
VC pass dated 1st of March 1971. But your VC pass has number, Mr. Abdullah.
My lord.
Your VC pass has number, 17 of 1971.
174. VC pass number is 174 of 1971.
Whose VC pass?
My VC pass.
174.
Yes.
From where you're saying that?
My lord, I think I have seen it from my LSC. Page 7 is my LSC.
No, I'm just looking at the judgment of the appellate court, additional district session judge,
See.
in RFA 21.
Yes.
At page 40, it says, second last para. On the other hand, VC pass number 17 of 1971,
Yes.
claimed by the appellant respondent, is also without blemish. Your VC pass is 17. How do you say it's 174?
17. Oh, I think I have seen somewhere else in the paper. Maybe 17, my lord.
Then what is the VC pass of the appellant in this case? The instant appellant?
That,
No number.
No number, just the date, as per the judgment.
1/3/1971.
Yes, Your Lordship.
But paragraph 13 says like that, Mr. Bilaramega.
My lord.
In short, the appellant as well as the respondent could not satisfy the court as to their rightful claim. Both parties have dubious claim. They could not, beyond reasonable doubt, prove their rightful claim over the disputed land. And yet it says appeal has merits. Evidence proved that the respondent plaintiff claimed the area much larger than this LSC.
I think this particularly says about the
VC pass,
yes, VC pass,
not the LSC.
not the LSC. The claim, the issue regarding the claim whether he claims larger than his actual area is still there, my lord. It has already been decided.
So far as the LSC, respective LSC is concerned, there's no issue.
There is no issue.
But both of you are having VC pass
Yes.
in addition to your
Yes,
LSC.
we mentioned about that, and we
So that is where some
location also.
encroachment has taken place.
Yes. So this is regarding that issue only, my lord.
If I may, just for the sake of clarity, Lordship, according to us, my LSC is here, then my VC pass is between my LSC and my learned friend's LSC, according to us. and that my VC pass was never considered. So in the LSC of the respondent plaintiff, the neighbor is mentioned as the present appellant. According to me, that my name being reflected in his LSC is not my LSC but my VC pass. That's where all the confusion appears to be happening.
They also have a VC pass.
Correct.
Between your land.
For them, their LSC is derived from the VC pass. First, it was a VC pass converted into a house pass in 2003, and finally into an LSC in 2014. According to us, they have only one land, and that emanated as a VC pass to a house pass to an LSC. Whereas in my situation, as can be seen from the
No,
declaratory,
VC pass to house pass.
house pass first.
Then LSC.
Yes, it's there. It's mentioned in their LSC itself at page 8.
So there is no more VC pass.
Yes, that
Because
was
that
supersede-
VC pass has been converted into house pass, thereafter to LSC.
Yes,
In your case, you have LSC, but you also have VC,
VC pass. According that, I mean, that is our version of the story. So that is where all the confusion appears to be happening. Now, no doubt, as per my LSC, my frontage is 52 meters. But I'm claiming beyond that is because I have my VC pass. My claim beyond the 52 meters is on the basis of my VC pass.
Then how come it is sometimes 90 something, sometimes 100 something?
No, in addition, by adding up my LSC and my VC pass, it comes up to 100, according to me.
That's what. But in some places I found it was mentioned as 93 or 92, something like that. And in some area it has come to more than 100
102.
102 maximum.
On the ground.
On the ground.
on the ground.
Yes. Either that, I believe the number varies between 98 and 102.
The land is not stretchable. That sometimes becomes smaller, becomes bigger.
No doubt. So maybe that persons who did the spot verification, maybe there was some mistake here and there. But the fact remains that it stretches between 98 and 102. So that is the crux of the case, Your Lordship, according to us.
But your limited points of argument which you had raised was regarding the spot verification done. The court had gone to the spot, and that has been solely relied upon. But the person who conducted, before that, you were not present at the time of spot verification because of COVID-19.
My lord.
And secondly, the person who had done the spot verification was not examined before the trial court, and you had not been given the opportunity to cross-examine. So same cannot be relied upon.
Right.
So basically what you're suggesting is that there should be a remand and a chance for me to examine.
Exactly.
Maybe fresh spot
Fresh spot
verification.
verification. Your Lordship, my late friend,
If you all agree, then we can send it back.
yes, with
You-
my learned
both of
friend's
you,
permission.
all of you be there this time, and you
I don't mean
have
to interrupt my learned friend, but with deep apologies, I had never pointed out the spot verification, which is at page 121 of the paper book.
because you were convinced that the court is convinced by your submission, so you did not bother to take out this one
I
to one.
absolutely missed it out. I apologize. And the second paragraph itself, Your Lordship, what I would like to point out, I was to perform joint spot verification with senior civil judge, 1 Aizawl the judicial district, and I therefore went to the chamber of the senior civil judge, who gave me instructions and directions, and I proceeded alone. On the spot, Zalian, seeing his sons, that is the present respondent plaintiff, and son JL Neilaya was present, and as instructed by the judge, we did not call the representative of Mr. Arthur Siama, as they were in isolation due to COVID-19, and so they were not present.
Okay. And who is this gentleman?
This is the gentleman who conducted the spot verification, the surveyor.
Bilal Rindika, survey 1.
Yes.
He went alone?
In the presence
alone.
of the representative of the plaintiff respondent.
No, that is there, but he
went
on his
alone.
part, he went alone from the
He went alone.
revenue. Normally they take some chainman or something like that with them.
Yes, Your Lordship.
One or
He
two
went
staff.
alone. He
He
went
went
alone.
alone.
I apologize to interrupt.
It's all right. So if it may be remanded back and fresh spot verification is to be conducted to clarify the issue, my lord, That could also be done.
If the parties
For
agree,
the
we'll do
interest
that.
of justice, that will be fair
We'll
enough.
do that.
That anyways is my limited grounds of appeal, so that I may be given an opportunity, that's all.
But what I'm trying to say is that despite that, yes, admittedly the surveyor was not examined before the court, and I admitted to that extent. But still, inspection of the court is there. So after saying all this, my lord, for the interest of justice, if it is remanded back and fresh verification will find out everything,
Okay.
whether it is actually encroached or not.
Please write. Heard Mr. Lal Fakoma, learned counsel for the appellant, and Mr. Bilal Ramenga, learned counsel for the respondent. Now, by filing this first appeal, the appellant has challenged the judgment and order dated 31/2023, passed by the Court of Senior Civil Judge, Roman 2, ISO, in eviction suit number 6 of 2014, by which the eviction suit has been decided in favor of the present respondent. And the instant appellant has been directed to demolish the Assam type building, garage, and 4 water tanks constructed within the constructed beyond his LSE number 203 of 1986, and vacate the occupation within a period of 3 months from the date of order. Stop. Next para. Brief facts of the case is that the appellant is the owner of LSC. The appellant has a plot of land covered by LSC number AZL 203 of 1986. Which is converted from a VC pass. Stop. The appellant also claims to have another plot of land adjacent to the said LSC covered by, what is the VC pass number?
It's only dated
Covered by VC pass dated
1/3/1971.
1/3/1971. Mr. Fakoma, please come to page 73 of the paper book. This is a map of the survey and map of your LSC.
My lord.
On the right-hand side, you find previously passed number. It says VC pass. There's no year or date, something like that. So could it be by any chance that VC pass which you just referred to, 1971?
I cannot confidently say, Lordship.
Okay.
I'll have to verify.
Stop. The instant respondent, on the other hand, also possess a certain plot of land covered by LSC number 103-702/01/2188 of 2014, which also has been converted. Where is that?
Page 8.
What about the VC pass?
VC pass was only mentioned in the RFA as
Converted from house pass number 209 of 2003. Stop alleging that there was certain encroachment over his land. The appellant filed declaratory suit. What is that? Page number?
'24.
Declaratory suit number 5 of 2001 before the Court of Assistant to Deputy Commissioner ISO. Praying for a declaration that he is the rightful owner of his suit land covered by LSC number AZL 203 of 1986, and that the same does not encroach upon the land of the instant respondent, who was arrayed as defendant number 5 in the declaratory suit. Stop. The declaratory suit was disposed of by the learned court below, with judgment and order dated 10/11/2006. By deciding the declaratory suit in favor of the instant appellant, as was prayed for. Stop. Next para. Aggrieved. The instant respondent, who was the defendant number 5 in the declaratory suit, filed RFA number 21 of 2006 before the Court of Additional District and Session Judge 1, ISO. Stop. The same was disposed of by judgment and order dated 22/3. थोड़ा बाद में आना, मैं डिक्टेशन दे रहा हूँ. What did I say? It was disposed of by judgment and order dated 22/3/2010. By setting aside the judgment and order dated 10/11/2006 passed by the court below in declaratory suit number 5 of 2001. Stop aggrieved with the same. The appellant preferred review petition number 5 of 2010 before the same court, which, however, was dismissed by judgment and order dated 30/11/2011. Stop the appellant thereafter approached this court by filing CRP number 7 of 2012, which again was dismissed by order dated 24/4/2012. Full stop. Next para. Subsequently, the instant respondent filed eviction suit number 6 of 2014 before the Court of Senior Civil Judge Aizawl for evicting the for demolition of the erection / construction made by the instant appellant within his LSC and to evict him accordingly. Stop. The eviction suit was decided on contest by the impugned judgment and order dated 31/2023 in favor of the respondent, who was the plaintiff. Stop. Aggrieved. The instant appellant, who was the defendant in the eviction suit, has filed the instant first appeal. Next para. Mr. Lal Fakoma, learned counsel for the appellant, submits that the eviction suit was primarily and mainly decided on the basis of the spot verification conducted by the surveyor concerned in the absence of the appellant on account of COVID-19. Stop. The surveyor was neither examined before the learned trial court to prove the report that he had submitted. And therefore, the appellant has been deprived of a chance to cross-examine the said surveyor. In support of his submission, the learned counsel has relied upon the case of Life Insurance Corporation of India and another versus Rampal Singh Bison, 2010, 4 SCC 491. Stop. Referring to the said decision, the learned counsel submits that it is a settled position in law that not only the documents produced before the court, but the contents of the documents are to be proved in accordance with law, so as to rely upon the same in favor of the party who has produced the said document. Stop. In the instant case, the same is lacking, and therefore the impugned judgment and order cannot be sustained and should be set aside. Next para, Mr. Bilal Ramega, learned counsel for the respondent. On the other hand, by referring to the judgment and order of the lower appellate court in RFA, what is that? RFA number 21 of 2006 submits that the lower appellate court had clearly come to a finding that the instant appellant had occupied land beyond what was covered by his LSC. To stop, the said finding was on the basis of the evidence available on record. Stop this apart, the learned trial court had also made an inspection of the disputed portion of the land by personally going to the spot in terms of Order 18, Rule 18 of the Code of Civil Procedure, 1908. Stop. Therefore, on the basis of such evidence available, the learned trial court passed the judgment and order directing the eviction of the unauthorized construction made by the appellant over the land of the respondent. Stop. In support of his submission, that the on-the-spot inspection of the court is permissible and can be relied upon by the court. He refers to the decision of a court. He refers to the decision of a coordinate bench of this court, rendered in President Bharat Sevashram Sangha versus Secretary to the Government of Meghalaya and others, 2013, 3 GLR 586. Referring to the said decision, the learned counsel submits that it was held by the court that inspection of the court under Order 18, Rule 18, CPC, is permissible when there are evidence on record. To stop, in the instant case, the plaintiff in the eviction suit, instead of plaintiff, you write, okay, you put that plaintiff, before that you write the respondent / plaintiff examined 3 witnesses, including herself, while the defendant / appellant examined himself as the lone defendant witness. Full stop. Therefore, the verification made by the spot inspection made by the learned trial court and the ultimate finding arrived at is only sustainable. Can I record that the joint that verification
May not be recorded, my lord.
may not be recorded?
Yes.
Okay. Next para. I have heard the submissions made by the learned counsels for the rival parties, and I have perused the materials available on record. Stop. Having regard to the specific stand taken by the appellant that he was not a party to the spot inspection, and also he has been deprived of the chance to examine and cross-examine the surveyor concerned who conducted the spot verification. And at the same time, having regard to the fact that the conclusion and decision arrived at by the learned trial court admittedly is on the basis of the spot verification done by the Department of Land Revenue and Settlement. I am of the considered view that merely exhibiting the spot verification report would not suffice to hold that the respondent plaintiff is entitled to the prayer of eviction made by her before the trial court, requiring the appellant to demolish the already constructed structures. Stop. Having come to such a finding, I am of the considered view that it is a fit case for remanding the matter back to the learned court below for consideration of the evidence led by the parties once again. Stop. Since the appellant clearly was not present at the time of spot verification done by the surveyor concerned, as can be seen from the survey report. Itself. comma, it would be in the interest of the parties and for the ends of justice that a fresh spot verification be ordered to be conducted by the department concerned in the presence of the parties concerned. What about the VC as well as? Do you have local counsel or VC?
Local council.
As well as the representatives of the village council / local council concerned. Stop such direction no, such from there you cut that, such direction. The direction for having a spot verification as stated here and above should be made by the learned trial court. On the appearance of the rival parties concerned before it. Full stop. The impugned judgment and order dated so and so is hereby set aside, and the matter is remanded back to the learned trial court for consideration as observed here and above. Stop. Since the parties are represented today, since both the parties are represented today, they are directed to appear before the learned trial court on which date would be convenient?
11 November, madam.
It's okay? On 11th November 2024. Along with a certified copy of this order, whereafter the learned trial court shall proceed with the matter as observed and directed herein above. Stop. Since the matter pertains to the, which year?
2014.
Pertains to the year 2014, the learned trial court shall make all endeavors to expeditiously dispose of the suit. With the above observation and direction, the appeal stands disposed of as allowed.
Deeply
As-
obliged.
Highly obliged.
I think I should keep this inside. Yes, the next case, who are the parties? Mr. Rokum, we'll come back in 5 minutes' time.
Item number 6.
Yes, Mr. Raghun.
May please your lordship, by this petition, the petitioners challenging the impeached order dated 9/10/2006, whereby the provident fund of contributed provident fund of the petitioner has been was forfeited by the respondent number one.
Where's the order?
That is page 37 and 30 annexure 4 lordship
37.
and 37.
Yes.
Lordship, the brief fact of the case is that
This is the typed copy, is it? This is the typed copy. Annexure 4.
yes, Lordship.
Where's the original copy? You have not enclosed the original copy. And you have not even said it's a typed copy. You are challenging this order?
Yes, Lordship.
Yes. Please carry on.
The brief fact of the case is that, Lordship, the petitioner husband, Lalnun Mai, was posted as a senior branch manager at Chairship, Lordship, 2004-2006. And then complaint was lodged against him regarding the misappropriations of the branch money, Lordship. And thereafter, departmental inquiry was conducted, and on the basis of the departmental inquiry, he was placed, that the service of the petitioner was dismissed, Lordship. That is page number 34, Lordship, annexure 2.
34 and extra 2.
Yes, Lordship.
What is this? Dismissal.
Yes, Lordship. This service of the petitioner husband was placed under dismiss, Lordship. And thereafter, Lordship, the criminal complaint was also lodged against him, and the criminal case trial number 1536 of 2000 under section 409 and 4465 was initiated against him, and after taking all the evidence, Lordship, the petitioner husband was convicted to undergo the period which he have already undergone during the trial of the case, Lordship. That is the relevant para is, Lordship, that is page 32, last paragraph, Lordship, may I go through?
Last third paragraph. From the evidence adduced. From that.
Yes, from the evidence of the accused. Sorry. Accused argument both party, I therefore found that the accused PC Lanun Moya, then the manager MRB CRC branch, had submitted false report and the head of his ISOL, and thereby committing offense under section 409-465 IPC, and I convicted him on the same. On the questions of the sentence, the accused is heard as per section 2352 of the CRPC. The accused has stated that he, being an officer, is already dismissed from his service. He had been attending court for the last 9 years without fail. He had this shameful case and over his head for the last 9 years, and he never forget even one day this criminal case being upon his head, and he had given more than what he is accused of. Therefore, he pray the court to have lenient considerations on what he had already gone through and be satisfied to the 9 years he had spent with the court case hanging over him. The prosecutions also did not press for the maximum punishment. On hearing both parties and on considerations of the money given back and the accused to the bank and the on considerations of what the accused had gone through the ordeals of the 9 years of the criminal case hanging over him, I am satisfied that justice will be made if the accused is sentenced to the period already undergone by him. Accordingly, I sentence the accused to the period already undergone by him. These articles are returned to the bench. This is the order of the criminal trial case. And thereafter, Lordship, the petitioner has also filed a money suit, Lordship. Petitioner also,
Money suit?
Yes.
Who?
The respondent number 1.
They filed money suit?
He filed a money suit for the recovery of discrepancies amount, Lordship. That is...
How much is the discrepancy?
5 lakhs.
How much is the embezzled amount?
Embezzled amount is, Lordship, 5 lakhs. $5.79.376, Lordship. That is in the annexure 4, second paragraph. That is embezzled amount. And the
Where is that?
That is page 37, Lordship. Page 37, second paragraph. That is in the middle.
9 lakhs.
9 lakhs is, that is another accused, Lordship. That is not, we have not go. Our case is, Lordship, it is 5 lakh, Lalun Moya, in respect of, there are 2 accused, Lordship. There's one accused is 9 lakhs and the present petitioner husband is 5 lakhs 79.
Is it like that? I don't think so.
No.
It says that while dismissal order was passed, you had no money in the bank. Bank could not recover its loss caused by you, amounting to 9,35,000, so and so. Now you have 5,79,000 in your account. So they have forfeited that amount. So loss cost to the bank is 9.35 lakhs.
Yes, Lordship.
Then what is this written in the judgment of the trial court in the criminal case?
Criminal case is only that is convicted to undergone.
No, I'm talking about the amount. The amount is different in the criminal case. You were examined under 313.
Yes.
He stated that amounting to rupees 5,66,000 was forfeited. An area of pay little over 101 lakhs was also held by the bank. And he also surrendered his suspense allowance amounting to 52,000. In all, amount of rupees 7,18,000 was surrendered by him to the bank. So what is the figure? That's what I'm asking you.
Yes, Lordship, that is 7,18,000 he has surrendered.
How much was misappropriated by you?
This 18,90,000.
18,90,000.
Embezzle amount of money is more than 18,90,000. That is as per prosecution witness number 3 said. But prosecution witness, he said that exact amount alleged embezzled by the accused. Accordingly, the PW4, the discrepancy was 6 lakhs on the transactions on 14 January 1997. The PWD7 KSIO stated that during his investigation, he found 18,90,000 was misappropriated by the accused.
Anyway, from the impugn order at page 37, figure is something else, 9,35,671.36 paisa.
Yes.
This is the amount.
Yes, this is the amount.
Why it keeps on varying? The amount keeps on varying. From 9 lakhs to again, you said 18,000, 18 lakhs, 90,000.
That is, Lordship, this as per the criminal case, the findings of the KSIO is different from the...
Anyway, we are not concerned with the criminal case, isn't it?
Yes,
we are
sir.
concerned only with page 37.
Yes, Lordship.
They have forfeited your money.
Yes.
You have challenged this.
Yes, I have.
On what ground?
We have challenged, Lordship, this as per as per section 10 of the Employment Provident Fund and the Miscellaneous Provisions Act 1952, Lordship, that this contributed provident fund cannot be attached or by order of any courts. This has to be given to the employee who has contributed, Lordship. That is...
Where is that?
That is page 28.
Page means you're having the same book?
Yes, Lordship.
Same book?
This 1952.
No, your edition will be different. This is 2024.
Yes.
The page will not be same. You just tell me the...
Section 10, Lordship.
Tell me the section.
Section
Yes.
10. May I go to Lord?
Protection against attachment. This one.
Yes, protection against attachment.
What is the heading of this chapter?
That
Section 10. Employees Provident Funds and Miscellaneous Provisions Act, 1952. Yes, read. What do you want to read?
Section 10 and subsection 1 and 2, Lordship. The protection against attachment. Amount standing to the credit of any members in the fund or any exempted employee or in provident fund shall not in any way be capable of being assigned or charged and shall not be liable to attachment under any decree or orders of any court in respect of any debts or liabilities incurred by the members or the exempted employee, and neither the officials assignee appointed under the Presidency Towns Insolvency Act 1909 and nor any receiver appointed under the Provincial Insolvency Act 1920 shall be entitled or have any claim on any such amount. Any amount standing to the credit of the members in the fund or an exempted employee in provident fund at the time of his death and payable to his nominee under the scheme or the rules of the Provident Fund shall, subject to the deduction authorized by the said scheme or rules, vested in the nominee and shall be free from any debt or other liabilities incurred by the deceased and the nominee before the deaths of the members or the exempted employee, and shall also not be liable to attach under any degree or any courts. That is contributed Provident Fund of the members is not liable to be attached at any point, Lordship. Even after his death also, his nominee is liable to receive that the amount. And Lordship, then the present Mizoram Rural Bank Officer and Employee Service Regulation 2010, that is Section 45, Lordship, this is the copy.
Yes, what does it provide?
Is provide that is Lordship, this during the proceeding after retirement, Lordship.
Section?
Section 45, page 12. An officer or employee who is under suspension or charge of the misconduct and who attained the age of superannuation shall be deemed to be in their service even after the age of superannuation for the specific purposes continuation and conclusions of their disciplinary proceeding and the issue of final orders thereon. The officers or employee who is under suspension shall not be eligible for any subsistence allowance for the period beyond the dates of the superannuation. The officers of employee against whom disciplinary proceeding has been initiated shall cease to be service on the date of the superannuation, but disciplinary proceeding shall continue as if he was in service until the proceedings are concluded and final order is passed in this respect. The officers or employee against whom disciplinary proceeding has been initiated shall not receive any pay or allowances after the date of superannuation and also not be entitled for the payment of retirement benefit till the proceeding is completed and final order is passed thereon, except his contribution to the contributory provident fund. Lordship, here it is mainly that even during the proceeding and after the proceeding also, the others allowance of pay and allowance may be attached, but this contributed provident fund cannot be attached or cannot be detailed, Lordship. That's what it is said so far according to my knowledge. And
in your case, there's no more proceeding. You have been terminated.
Yes.
No proceeding. You were terminated.
Yes.
You are convicted also.
Yes. I'm convicted. And Lordship, even in the CPC, the civil in the CPC, Lordship.
See, the impugn order does not say that your provident fund is attached. It just says that your money of 5 lakhs is attached.
Lordship, it is not allowed to be attached, Lordship, contributed provident fund.
Where does it say this is your contributory fund, provident fund? See the impugn order.
Yes, this is my contributed provident fund.
How do we know that?
Lordship, that I'm coming. That during the incumbent officers would expire on that is 2006, Lordship. 2016. Before that, Lordship, he has submitted representation to the Commissioner, Regional Provident Fund Shillong, and that they have a letter, 2 letters, that this contributed provident fund cannot be appropriated at any cost for any other debt. It has to be given, Lordship.
Where is that letter?
Yes, I'm coming, Lordship. This page 39 is my representation to the Regional Provident Fund Commissioner Shillong, Lordship. This.
Dated 2006.
Yes. Dated 3/11/2006, Lordship. And Lordship, page 40, Annexure 6 is their reply, Lordship. Page 41.
Just a minute. Please come to page 39. Second para.
Yes, Lordship. Even before I know that the above amount of money was...
No, that's not second para. That's, sir, as you are aware, this is the second para. Have you got it?
Yes.
Read that.
That,
sir,
you are aware I submitted a claim for final settlement of Provident Fund after Mizoram Rural Bank Authority removed me from the service. As a result, sanction was made by your office and the settled amount was remitted to the branch manager Mizoram Rural Bank Aizawl via check number 891113 amounting to rupees 5.79.37.
okay, you stop there. So this is the figure,
Yes.
correct?
Yes.
Same figure in the impugn order, 579,376.
Yes.
This is the amount towards your Provident Fund.
Yes, Lordship.
What is the reply?
The reply is, Lordship, page 40. That is type copy is page 41, Lordship.
Yes, read.
Forfeiture attachment of Provident Funds money in respect of the Sri Zoming Thanga Holding PF such and such and PC Lalmun Moya Holding PF account number AS 1671 2023 with reference to the subject cited above. The undersigned had received representation from Zoming Thanga and CPC Lalmun Moya informing that their Provident Fund money of rupees 8 pounds settled via check number such and such and rupees 5.79.376 settled via check number such as in respectively have been forfeited and attached via order dated 9/10/2006 passed by the chairman Mizoram, that is respondent number 1 Lordship Bank, in exercise of the power conferred under sections 21 General Clause Act. In connection with the representations as stated above, it is to draw your kind attention to the provisions laid down under Section 10 of the Employee Provident Fund and Miscellaneous Provident Fund Act 1952 and Section 61K of the Code of Civil Procedure 1908, wherein it has been clearly written that the compulsory deposit and other sum in any funds of the derived from any funds to which Employee Provident Fund Act 52 for the time being applies shall not be liable to attachment insofar as they are declared by the Act not to be liable to be attachment. This provision clearly shows that Provident Fund money or any sum derived from Provident Fund are immune to forfeiture or attachment. In view of this, the undersigned is constrained to direct you to refund the Provident Fund money in respect of the Sri Zoming Thanga and PC Lalmun Moy illegally forfeited.
Okay, now there are two figures here. One is Provident Fund money of rupees 4,85,000 so and one is 5,79,000. You have received 2 checks. How much Provident Fund have you received?
That is.
Are you
that is
entitled to?
For 4,85,000. This is in respect of Zoming Thanga. That is another officer, Lordship.
Oh, I see. This is Omid Thang.
Yes, another
Petitioner
officer.
is PC Lan Moya.
Yeah, PC Landunwai. His amount is 5.79.376.
Okay. So this was the letter from the Provident Fund.
Yes, Commissioner Provident Fund Regional Office in Auckland.
The date is 2006.
Yes.
Then why did you file your writ petition in 2023?
Lordship, 2006, the petitioner, that is the officer was expired. He has been
When?
2016, Lordship.
16. Oh, but he was around when in 2006. Recovery was made in 2006, November. No, it was made in October 2006. November 2006, he wrote to the Provident Fund Commissioner, and in November 2006, the reply came. Then you filed writ petition in 2023.
Lordship, for donation part is already over, Lordship. That
I
is
know. I've read the file. There was a
Lordship,
preliminary objection raised about the delay.
Lordship, that is.
But I want to ask you again, why did you simply sit over it?
Lordship, that is, petitioner was suffering from this acute diabetes and
Petitioner?
that petitioner husband, that PC London Moya. And he could not come due to financial problems, Lordship. And thereafter, after his death, there was a pandemic.
Okay, we'll come back at 2. All right.
Yes, sir. May I please, Your Honor.
Yes,
Yes,
sir.
Page number 44, Lordship, another annexure.
44.
Yes,
What is that?
Lordship. That is another letter from the Employment Provident Fund Regional Office Shillong to the respondent number 1, Lordship. May I go to?
Where's the original copy? Anyway, it's the same thing.
Yes.
What is this section 61K of the CPC?
Yes, Lordship.
61K.
61. Lordship, this 60 is property liable to be attached and sell in execution of decree, provided that the following particulars shall not be liable to be such attachment or sale, namely the what A, B, C, D, and K is, Lordship, this all compulsory deposit and other sum in order or derived from any fund to which Provident Fund Act 1925
Okay.
for
Okay,
the
I got
time
it.
being enforced. That.
I got it. Now, what else?
And Lordship, this page 46, annexure 9, that is the order of the court. The
Which court?
this
Money suit.
money suit. Yes, there's a money suit. That is page 47, 9, and that is the.
What is the sum and substance?
Type copy. That is case record call and
Dismissal and withdrawal.
yes, dismissal on withdrawal. That is they have withdrawn the
No, so
civil the money.
dismissal and withdrawal.
Yes.
So how does it have any bearing on this case? They may file, they may withdraw. It's up to them. Your basic case is that this money cannot be forfeited.
Yes, Lordship, that is my case.
You have any authority?
The authority, that is, Lordship, there's existing, that is as existing their rules.
Apart from the rules, CPC,
Apart from the CPC,
rules, CPC and Provident Fund,
Provident
any
Fund.
authority of the Supreme Court?
in fact, Lordship,
You
I
did
do
not
not
prepare.
have any. I don't have any. I
You have
just
found at
depend
least
on
one,
the-
two judgments to reinforce your case.
Yes, yes, Lordship,
So that is your case, basically.
yes.
Let me hear you. Mr. Zoramchana.
My Lordship. May it please, Lordship. Beginner's time has now already passed. Regarding the delay, Lordship, actually 18 years, but that already, yes, Lordship. No,
Decided. You have not filed appeal.
Sorry.
You have not filed appeal challenging that order.
No,
So delay is gone.
I was actually advising, but since there was some, I think I've got some advice to go for appeal, but that's a little late. So I think on merit also, I think we have case.
See, this morning you were just saying that this money, once it goes to the account,
My Lord.
it is no longer, it can no
Provident
longer
fund.
be
It doesn't
known
have-
as a provident fund money.
My.
So if we forfeit from the account of the
Saving bank.
petitioner,
Saving account.
what is wrong in that? There's nothing wrong because he has misappropriated certain amount of money. Although we could not get full recovery, at least some amount we could recover.
My Lord.
But one thing which I find here is in the representation, petitioner has specifically mentioned with his prayer to the commissioner of this provident fund, white check number so and so, this amount you have given me has been forfeited. Do something. Please help me. So the money which is indicated in the impugned letter is just the same. So it is not just any money. In fact, it is that money, provident money, which
I agree
has
with Lordship.
which has been deposited in his account.
Before, it was credited into the account, the saving account of the petitioner. My Lord. Yeah, that's correct, my Lord. But the moment, my Lord, it's been credited into the saving account of the petitioner, it no longer bears any color of being a provident fund. It's only a normal fund, along with all the other fund that the petitioner might have collected, maybe from his business or personal, whatever, my Lord. And all these monies, all these funds, all these sources come together into his saving account. And the moment it's credited in there, then it's a normal fund, my Lord. So,
So how will he enjoy the Provident Fund if it is not credited to his account? They will give him by cash. Take like that.
actually, he can also very well have another account.
How will he
from-
enjoy?
Yes, he can also have
First
it.
of all, they'll ask you, nowadays they'll ask you, do you have Aadhaar card? If you don't have Aadhaar card, nothing doing. So all those things are required.
Mile.
Now in this case
They have,
also,
they have to have a
in
certain,
this case also, they'll ask him, do you have an account? He said, yes, I have an account. Where? Rural bank or whatever bank. Then they'll credit there.
Actually,
And the moment it gets there, you capture it. You
Mine.
say that this money, you're not getting it because you have embezzled so much money, we are taking this money. This is not Provident Fund money because it is already entered in your account. How can you say that?
because the moment it's being credited, that's normal. So they can, if they do not have it forfeited for that embezzled money, they can very well have account in some other bank, that is outside our authority.
Let us not imagine too much on that.
Anyway, so that's my contention, Your Lordship. So actually,
Any other stand?
uh,
What have you
Yes,
said
my lord,
in your affidavit? What have you said?
I now they have not now since this order which they have impugned herein in this petition, my lord, is a part and parcel of the dismissal order, my lord. It's a part of the dismissal order, my lord. In terms of Section 21 of the General Process Act, my lord, we have that also invoked, my lord. So it's a continuation of the dismissal order.
Okay.
So
Even if we accept that,
So, what my contention, my lord, is that they now have not preferred any statutory appeal also. That they have not, they have not gone. They have not exhausted also.
okay.
That, as
So-
per Regulation 49 of the Regulation 10 of
Okay.
the MBR, they have the avenue, my lord.
Just
That they
let me
have-
complete the sentence. Even if we accept the General Clauses Act that it's in continuation, but the fact remains that the issue as to whether you can forfeit the what do you call this
Provident Fund.
Provident Fund money still there.
My contention, my lord.
It is still there.
My humble contention
Delay
is
is there. You said delay is gone. Now no appeal. Okay, that's another issue. No appeal was filed. But these are all technicalities.
my lord. But we have not attached any provident fund, my lord, in the present case. We have not attached or we have not forfeited any provident fund
Then
belonging
what-
to the petitioner. my lord.
Okay, then what is that
my
money?
contention.
Then what is that money then? 5 lakhs.
That money, my lord, that money is the normal money credited into the saving account, my lord.
It just appeared in his account, so we forfeited. How can you say
Yes.
that? It appeared from Provident Fund.
No, my lord, the source doesn't make a difference, my lord. The source may be any other difference from his personal business. They all come together within that saving bank. Within that saving bank, my lord, there is no separate compartment saying that, oh, since this comes from PF, GPF, this comes from business, this comes from personal, whatever, my lord. There is no separate compartment within the saving bank, my lord.
That is why I was very specific about the
My lord.
figure.
The moment it comes,
The figure is exactly the same.
yes, my lord.
Had there been some variation, 5 lakhs deducted, and if the amount had come like 6 lakhs, 7 lakhs, we would have said, okay, this is different. But the bank check number is also mentioned. Amount is also same. Figures are all same.
That check number is important as long as it's before credited. Once it is credited, the check number, everything has no bearing. It's credited in the saving bank. And now it's also stated here in the one order saying that since the petitioner at the time of imposing of penalty has no money at all to be deducted, my lord, towards making good of all the losses caused to him by the bank, to the bank. So once that money has been credited, then that is all with all the small figures, my lord, has to be deducted, my lord, forfeited.
So he has no money at all. You only say that this money is accumulated from other business here and that. So he had no business at all. He had nothing. Only money came from the Provident Fund, immediately you grabbed it.
That, my lord, is beyond my knowledge. So actually and technically also, my lord, that doesn't bear any semblance of any for provident fund or anything like that. So in this present case, my lord, there seems to be some misunderstanding saying of the fact that that fund is still the provident fund. But to my humble submission, my lord, and opinion, my lord, that doesn't have any color of being a provident fund. It's only a normal fund, just like any other fund. The moment it's been credited into the saving bank's account, it's okay, my lord. So we can very well have it attached, very well have it forfeited for any, to make good any loss caused to the bank by the petitioner, my lord. And since that, my lord, is also part and parcel of the dismissal order, on the, since this sort of a quantum, my lord, on the quantum, my lord, the DA, the prescriptive authority, my lord, as your lordship knows very well, have authority, my lord. I'd like to place one authority regarding that, saying that the disciplinary authority is having sole power, authority on adequacy, my lord. Adequacy or
Yes.
quantum of
What is
penalty,
that?
my
What
lord.
is the citation?
To the 1995, your lordship.
1995,
Volume 6 SCC
6 SCC
749.
749, paragraph
Relevant paragraph is para 18, my lord, 18.
18. Read.
Yes, your lord. Para 18, a review of the above legal position would establish that the disciplinary authority and on appeal, the appellate authority, being fact-finding authorities, have exclusive power to consider the evidence with a view to maintain discipline. They are invested with the discretion to impose appropriate punishment, keeping in view the magnitude or gravity of the misconduct. The High Court tribunal, while exercising the power of judicial review, cannot normally substitute its own conclusion on penalty and impose some other penalty.
Yes. Basically, it says that even if it shocks the conscience of the court,
My lord, they can
court
very
will
well,
not substitute the penalty
My
on
lord,
its own.
my
It will remand the matter back
Back.
to the disciplinary authority
yes,
to reconsider and
consider,
give the
yes,
appropriate.
exactly.
Okay. Anything
And-
else?
Regarding one fact which my learned friend has shown to your lordship regarding the statement made in the judgment of the trial court in the criminal case, my lord.
Yes.
There is one specific
Page 32.
statement which I think is quite crucial here, my lord.
Page
Page 32.
32, yes.
32, my lord. On the second paragraph, Lord. The paragraph that begins with the accused himself. In his examination, number 313 stated that his GPF amounting to so and so were forfeited by the bank. His area of pay, little over 1 lakh, was withheld by the bank, and he also surrendered his suspend allowance amounting to so and so to the bank. In all, the amount so and so were surrendered by him to the bank. Therefore, the accused P.C. Moya also held himself responsible. This is the statement given by the trial court, my lord. And my lord, down there, for the detected discrepancies of the case, and he has willingly, my lord, willingly surrendered the above said amount to the bank.
What
And
is the
after
amount?
saying the said amount includes the present disputed amount, my lord. So now, after having some afterthought, my lord, they come to again, my lord, after 18 years, challenging, saying that that amount from GPF has to be mine. So this, my lord, has already been admitted by him before the trial court in the criminal case.
Okay.
So actually, that's the substance, sum and substance, my lord, of my case.
Okay. That's it?
My lord.
Okay. I'll dictate the order. Mr. Rokum, you take your seat. Heard Mr. A.K. Rokum, learned counsel for the petitioner, and Mr. C. Zoram Chana, learned standing counsel, Mizoram Rural Bank, appearing for all the respondents. All Provident Fund is there?
GPF.
For respondent number 3, I'm appearing.
Sorry. No, just a minute. Mr. Caesar Ramchana, learned standing counsel, Mr. Rural Bank, appearing for respondent numbers 1 and 2.
1 and 2.
And Mr. Ram Murmu, learned counsel, appearing for respondent number 3. Stop. The short question involved in the instant case is as to whether the Provident Fund money of an employee can be forfeited for recovering alleged embezzled amount. Stop. Next para. Brief facts of the case. For disposal of the instant writ petition is that the petitioner's husband was working as what? Branch manager?
Senior branch manager,
Senior branch manager
MRB, Church,
under the
Mizoram Rural Bank,
Mizoram Rural Bank, Sechi branch
Church branch.
at the relevant time. And certain allegation was made against him for embezzlement of the bank's money after a departmental proceeding was drawn against him, the same culminated into imposition of a penalty of dismissal upon him, by order dated 30/3/2005. At the same time, criminal proceeding was drawn against him through criminal trial number 1536 of 2000. On being charged under section 409/465/471 of the Indian Penal Code, bracket IPC. The criminal trial concluded with the conviction of the husband of the petitioner under section 409/465 IPC. In so far as the sentence was concerned, the trial court sentenced him for the period already undergone by him to stop. Did I give you the date of judgment? Just add that in the last line without full stop. Void judgment in order dated 29/12/2009. Full stop. Prior to the disposal of the criminal trial, the bank authorities, void order dated 9/10/2006, had forfeited a sum of rupees 5,79,376 from the husband of the petitioner. Before husband, you just add this from the bank account of the husband of the petitioner. So as to recover the loss caused by him to the bank. Next para. The husband of the petitioner, being aggrieved, submitted how many? 2 representations. 2. How many representations did you submit to
one representation
to the commissioner?
Yes.
Only one.
Yes. One.
Submitted a representation to the Regional Provident Fund Commissioner at Shillong, Meghalaya, on 3/11/2006, complaining that the Provident Fund money received by him had been forfeited by the bank, and therefore requested that the same be asked to be refunded to him. So in response, the Assistant Commissioner of Provident Fund, via communication dated 9/11/2006, wrote to the chairman, Mizoram Rural Bank, Zarkot Aizol, to refund the Provident Fund money to the husband of the petitioner, since the same cannot be forfeited in view of the provisions of Section 10 of the Employees Provident Funds and Miscellaneous Provisions Act 1952. Bracket. (1952) Act, close bracket, and also Section 60 bracket 1 bracket small k of the Code of Civil Procedure, 1908 bracket CPC. Full stop. A similar communication was again made to the Chairman, Mizoram Rural Bank, Aizawl, on 15/12/2006 by the Assistant Provident Fund Commissioner, asking the bank to refund the Provident Fund money to the husband of the petitioner and to submit a confirmation in this regard. After submit, you write back, BSEK, submit back a confirmation in this regard. Stop. Despite the same, the amount has not been refunded. To stop, the husband of the petitioner in the meantime expired in the year 2016, and it is the petitioner who is his wife who has filed the instant writ petition. Seeking for a direction to the respondent authorities to refund the Provident Fund money to her, since she's the legal heir of her husband, of her late husband. Stop. Next para. Mr. A.K. Rokum, Learned Counsel, submits that it is clear from the provisions of the 1952 Act as well as from section 61 bracket K, small k, that the
Lordship, I interpret this Mizoram Rural Bank notification that Mizoram Rural Bank Officers and Employee Service Regulation 2010, Section 45 also same, also have stated the same, Lordship.
What did I say? That the Provident Fund money cannot be deducted or attached on any account. To stop. He submits that likewise, as per Regulation 45 bracket 4 of the Mizoram Rural Bank, open bracket, officers and employees, close bracket, service regulations, 2010.
Subsection 4, my lord.
All the benefits entitled to an employee can be put on hold except the contribution of the employee towards contributory provident fund. Stop. He therefore submits that the amount that has been forfeited should be refunded to the petitioner. With interest at the rate of 7% per annum. Next para. Per contra, Mr. C. Zoram Chana, learned standing counsel, Mizoram Rural Bank, submits that the amount that has been forfeited from the husband of the petitioner was the amount which was available in his savings account, and not a direct forfeiture of the Provident Fund money. Full stop. He submits that once the amount has been credited to the savings account, of the account holder the same loses the color of its source. Full stop. He further submits that the late husband of the petitioner was convicted by the learned trial court, quite the judgment and order dated 29/12/2009, wherein it was clearly recorded that the late husband of the petitioner himself petitioner held himself responsible for the discrepancies in the bank, and he willingly surrendered the amount which included the amount to be received, the amount received towards the amount received from the General Provident Fund. Full stop. Therefore, the instant writ petition has been filed only as an afterthought, without even availing the remedy of filing an appeal before the appellate authority, either by the late husband of the petitioner or the instant petitioner. Stop. The Learned Counsel also submits that the order dated 9/10/2006 has been passed in continuation to the order of dismissal from service dated 30/3/2005. as permissible under the relevant provisions of the General Clauses Act 1897. 1897. Stop. He thus submits that the writ petition has no merit and the same should be dismissed. Next para, Mr. Ram Murmu, Learned Counsel for Respondent
If
number.
I may, Lordship, my citation, please, ma'am.
Okay, before that you write, in support of his submission, the Learned Counsel has relied upon the case of B.C. Chaturvedi versus, sorry, this is the one. Yes, B.C. Chaturvedi versus Union of India and others, 1995, 6 SCC 749. Next para, Mr. Ram Murmu, Learned Counsel for Respondent number 3, submits that the respondent number 3 basically is a pro forma respondent, and that the respondent number 1 and 2 had been communicated at the relevant time by the Regional Provident Fund by the officials of the Employees Provident Fund Organization, Northeastern Region Sub-Regional Office at Shillong, by informing the respondent numbers 1 and 2 that the amount of money the Provident Fund money cannot be forfeited, and the same should be refunded to the husband of the petitioner. In view of the provisions contained under the 1952 Act, as well as under Section 661 bracket, what was that? T, small k, 661K of the CPC. Anything you want to add?
My Lord, in my written objection, para 5, regarding that our side, Provident Fund accumulated toward the petitioner husband, we have released the fund to the respondent number 1. void check dated, which has been stated in para number 3 of the
that I've
petition.
seen.
That's all, yes.
Next para, I have heard the submissions made by the learned counsels for the rebel parties, and I have perused the materials available on record. Stop. As already stated in the preceding paragraph, the question to be, the issue to be considered is as to whether the Provident Fund money of the husband of the petitioner no, as to whether the Provident Fund money of the late husband of the petitioner can be forfeited by the respondent bank in the manner it was done by the impugn order dated 9/10/2006. Stop. The impugn order indicates that a sum of rupees 5,79,376 within bracket inwards, okay, only was forfeited from the saving bank's account of the late husband of the petitioner to recover the loss caused by him to the Mizoram Rural Bank. Stop. To consider as to whether the same can be forfeited, Section 10 of the 1952 Act may be abstracted hereunder. Page 29, pink flag, A to A. Next paragraph, from the above abstract, it may be seen that the amount standing to the credit of any member of the fund is not liable to be attached under any decree or order of any court in respect of any debt or liability incurred by the member. So in the instant case, the impugn order provides that the amount that was forfeited is for the purpose of recovering the loss caused by the late husband of the petitioner to the Mizoram Rural Bank. Then next paragraph. It may further be seen that as per section 60 bracket 1 bracket small k of the CPC, it is provided that all compulsory deposits and other sums in or derived from any fund to which the Provident Funds Act for the time being applies insofar as they are declared by the said Act is not liable to be attached. Stop. Similarly, the regulation 45 bracket 4 of the regulation of 2010, that long name, na? You put regulation of 2010. If you go back, of regulation of 45 4 of regulation 2010 also does not permit holding back of any amount which is contributed to contributory provident fund. Stop. Therefore, having regard to the protection as contained in the aforesaid provisions, it only appears that the amount which was forfeited from the provident fund money to be received by the petitioner's late husband. Please read that sentence. Has been wrongly forfeited. The case of B.C. Chaturvedi, Supra, relied upon by the learned counsel for the petitioner, is in respect of
Respondent, man.
For the respondent is in respect of the imposition of, in respect of the modification of the penalty imposed upon the delinquent officer. Stop. According to the Apex Code, even if such penalty is to be modified, the same should be referred back to the disciplinary authority for imposition of appropriate punishment. Stop. The same, however, in the considered view of this court, will not be applicable to the instant case, since the very imposition of the very forfeiture of the Provident Fund money is not permissible in law. Next para. In view of above, the respondent numbers 1 and 2 are directed to refund the forfeited amount of Provident Fund money to the petitioner, who is the legal heir of the late employee of the bank. stop. Ordinarily, court would have considered imposition of appropriate interest along with the refund. But since the petitioner has approached this court
17 years.
after about 17 years,
17 years.
and therefore interest is not being imposed. Full stop. However, the respondent number 1 and 2 shall refund the foresaid amount of rupees so and so. You have that figure, isn't it? Within a period of
2 months.
2 months from the date of receipt of a certified copy of this order, failing which the respondent number 1 and 2 shall be liable to pay interest at the rate of, what is the bank interest today?
Saving bank is 5%.
5% per annum till the entire amount is fully paid. Next para, with the above observation and direction, the writ petition stands disposed of as allowed. Please write in the subsequent paragraph. This has to be inserted somewhere. I had forgotten to mention one thing. Please write like this. Although the learned counsel for the respondent has mentioned that once the amount is credited to the account of the petitioner's late husband, the same loses the color of its source. The same, according to the in the considered view of this court, cannot be accepted. More particularly, when there is a specific reference that the amount was credited in the account of the petitioner's late husband, white check number 89114131. I'll repeat, 891112, amounting to rupees 579,376, which exactly is the amount which has been forfeited from the account of the petitioner's late husband, by the impugn order dated 9/10/2006. Full stop. Therefore, the contention made by the learned counsel for the respondent cannot be accepted. This will insert, okay, before the finding.
Obliged.
Deeply obliged.